Good afternoon.
Good afternoon.
Before the short adjournment, we were on my ground 7.
Yes.
We were looking at Rossendale.
Yes.
I said I was going to do two things. First of all, go to Rossendale, then go to our case and say why Rossendale is relevant. Done the first of those, we're now moving to the second.
Yes.
So, what we say is our position as set out at 37.31 and 37.32 and 37.4. So that's where I am in my skeleton argument. And essentially that's 2 points. First, I say that there can be no real question that in the present case, the scheme, which includes the issuing of the note, is accurately described, adopting the language of Gilbert, cited in Ramsey and Rossendale, it's paragraph 11 of Rossendale, as a transaction that does not appreciably affect the beneficial interest of the participating taxpayer. Now, my learned friend takes issue with that. He says that Mrs Elborne's beneficial interest is affected. That's paragraph 26 of the Elborne skeleton. I say that misses the point. In Gilbert, Mr Justice Hand is not making a nice point about English trust law principles. He's making a broader point about transactions which don't seem to impact upon a person's real financial position. That's clear both from the context. We can turn it up if the court would like to, but they may not wish to. But I say it's clear both from the context of what he says. He's talking about shares and dividends in the Income Tax Act. I say it's also clear from what he specifically says at the end of the paragraph in question. It's page 222 in the authorities bundle. Perhaps it is. Perhaps I will.
Have a look.
Yeah. Tab 21. So this is the case of, it's page 209, tab 21, it's the case of Gilbert. It's cited in Ramsey and then in turn cited in Rossendale at paragraph 11 that we looked at. And the passage which is utilised by Lord Wilberforce, Ramsey, and Lord Briggs in Rossendale is on page 411, the sidelined text, page 221 in the bundle. And my submission is that this is a case where the transaction does not appreciably affect the participating taxpayer's beneficial interest except to reduce his tax. That's the Gilbert formulation, the Justice Hand formulation at yes, about a dozen lines down, right-hand column, page 411 or 221 of the bundle. If, however, the taxpayer enters into a transaction that does not appreciably affect his beneficial interest except to reduce his tax. It's that point. I was saying that does fairly apply to this case. The other side say, no, it doesn't. The beneficial interest does change. I say that misses the point that there's actually a broader point being made here. It's a point about the real financial position of the person who enters into the transaction rather than a fine English trust law point. And I get the financial position point from the end of this paragraph, which is just over the page on page 412, where there's a reference to only those transactions that do not appreciably change the taxpayer's financial position, either beneficially or detrimentally. And I'm simply making the point that Mr. Justice Hand is making is a broader one than simply a sort of fine English trust law point. So that's my first point. This is a case which is fairly described as falling within the ambit of that sort of idea. And it's paragraph 37.31 of my skeleton. The second point I've got, this is 37.32 and 37.4 of my skeleton, is that although the tribunals took the view that one could not, as a matter of statutory construction, reach the conclusion that the revenue was contending for on liabilities under Section 49 via Rossendale and the Ramsey Bainham Authority more generally. I say that fails to appreciate the context in which the point comes to be considered. I would frame the situation in this way. Insofar as one is looking at this case with a focus on liabilities, our primary position is that the FTT got it right for the reasons it gave. That's to say, the logical consequence, and I would say the necessary logical consequence, of Section 49 deeming that an interest in possession beneficiary is treated as owning the trust property, is that when it comes to looking at Section 103, the same individual is treated as owning or incurring the trust liabilities, and thus the liability arising under the note is caught. However, if I'm wrong about that, if that's not how the legislation works, then I say it's legitimate to stand back and look at the position, and I would say this: given that the IHT legislative regime clearly does seek to factor liabilities into the inheritance tax analysis, some liabilities deductible, some not, can the liability in this case really be the sort of liability which Parliament intended to fall within the former category, deductible, rather than the latter category, not deductible?
I can well see that you could use that argument as an aid to a construction of the statute. So, on Ramsey principles, let's look at it with the view of the purpose of the legislation in mind. But it's not a freestanding point. You can't say, if as a matter of the purpose of construction of the statute I don't get home, oh, it's terribly desirable that I get home, so let's try and read the statute in a way that it doesn't actually provide. That doesn't work, does it? It's got to be an aid to construction.
It has indeed, milady. Absolutely agree with that. So my point is, if I'm wrong about how the legislation works in relation to Section 103, I say it's fair enough to sit back and say, well, okay, so what's going on here? And the point I'm developing is to say, is the liability in this case the sort of liability that Parliament can have intended to be treated as deductible rather than not deductible? Now, I say
Section 5.
If I could just...
Well, I just wonder, where are we dealing with the deduction now? If
Okay.
it's not covered by 103, the other part that deals with deductibility is either Section 5 or one of the other sections that you haven't taken us to, or there's the inherent deduction thesis that you issue in Mr. Justice Mann's decision.
So, milady, I am going to answer your question. I'm not avoiding it, I'm just running up towards it, if that's okay. So, I say that's not Parliament's intent, and I say Rossendale is a very good example of a case where if you pause for breath and, as it were, cross-check what you're doing, you land in a place where perhaps at first blush it wasn't the most obvious place to land, but ultimately it must be the right place because the Supreme Court said it was the right place. So this is, as it were, a cross-check analysis if I'm wrong about how the legislation works. Now, the complaint that is made against me, I think including by my lady, Lady Just Andrews, is that there's no valid process of statutory construction which can bring the Rossendale-Ramsey purpose of construction to bear. But I say that's not right. So I would say that on any view, the process of statutory construction which we are embarked upon, whether by either of the tribunals in this case, or by either of the parties in this case, or by Mr. Justice Mann in St Barbe Green, is a process in which one is endeavouring to discern Parliament's intention in respect of liabilities by construing the legislation, including, importantly, by reading in components which are not expressed in terms. That's what everybody is doing here. Whether that's an analysis that liabilities are dealt with through some sort of metaphysical net property concept, Mr. Justice Man in paragraph 12, or whether it's the analysis that the UT gets to using that as the springboard, or the FTT gets to using that as the springboard, everybody is trying to ascertain Parliament's intent, including by reading in components which are not expressly stated. Now, it's revealing, I say, to note the basis on which the Upper Tribunal rejected the Revenue's submissions on this point. I'd like to deal with that now, if I may. The pith of the Upper Tribunal's rejection is at paragraph 135 of the Upper Tribunal's decision. That sits within a run of paragraphs under the heading Discussion, which is dealing with this point, which runs from 127 to 137. So we're at 135. And this is the basis on which what's been called the Rossendale submission gets rejected. And there are 2 points being made here. So, point number 1, we do not accept Mr. Davies' submission that these facts represent an unusual case such that the liability represented by the note should not be deducted when valuing the property to which Mrs. Elborne is treated as beneficially entitled. The language and statutory context of section 49(1) does not support this submission, and the 84 Act includes specific provisions for disallowance of certain liabilities, e.g. section 101, 103. And then a second point. Moreover, whilst in Rossendale, Lord Briggs and Lord Leggett referred to the SPVs as having no real or practical ability to exercise their legal right to possession, and to that legal right having been conferred for no purpose other than the avoidance of liability for rates, in the present case, the FTT made findings as to the note giving rise to a debt, and there was no finding as to the purpose of the life trustees in issuing the note on its particular terms. So, 2 points are made against me. I say neither is a good point. I'll deal with each in turn. So the first point, not an unusual case, and statutory provisions deal with liabilities. Well, in terms of the basic idea that this is not an unusual case, I won't repeat what I said in opening. I say it is an unusual case factually. If it isn't unusual, I'm not quite sure what is. As to the point that the legislation already makes provision for disallowance of certain liabilities, e.g. under section 103, that's true. But I say it misses the very premise of this vein of analysis. Namely that what one has here is an entirely tax-driven set of arrangements which has created a liability, yet in relation to which, on the UT's analysis, and on my learned friend's case, one never gets to ask the basic and fundamentally important question, is the liability deductible? On the UT's analysis, one doesn't get there because the deeming under section 49 is no longer in play when one gets to section 103. And on my learned friend's case, at the heart of his analysis is section 1624. He says that's the source of the right to deduct trust liabilities. But I say that can't be the answer. As stated in the Upper Tribunal's decision at paragraph 34(1), which records my submissions on 1624, This is a section which, well, it sits under the heading Valuation towards the back of the Act and is addressing the position in respect of certain deductible liabilities. It says that should be set so far as possible against the properties they encumber. It's not, I say, dealing with the logically prior question of whether the liability is deductible in the first place. So it's well and good for the UT to say that the Act includes specific provisions to deal with disallowing certain liabilities. But if the analysis really is that none of them appear to be in play in this case, which I say would be rather extraordinary, then it's not unreasonable to go back to basics and consider what must really be going on when one looks at Section 49 and or Section 5.3. And so these are the particular provisions that I'm asking the court to look at to answer the Lady Justice Andrews' point. I'd be grateful if the court would read the submissions at 39.1 and 39.2 of our skeleton argument. I'm grateful. That essentially is what I say the process of statutory construction is, how we put it at 39.1 and 39.2. And as I say, the premise on which one undertakes this exercise is a situation in which it turns out that the way that we have been construing the legislation is wrong, and the question is what to do with this liability and what Parliament's intent in relation to it would be. Essentially, I say the analysis is at 39.1 or 39.2. So there were 2 points made against me on this. The first was that there wasn't a process to get there. I've addressed the court on that. And then the second was that, again, this was Upper Tribunal 135. The FTT, so quotes, the FTT made findings as to the note giving rise to a debt, and there was no finding as to the purpose of the life trustees in issuing the note on its particular terms. So this is the second of the 2 points that the Upper Tribunal takes in rejecting this argument. Again, I say that's an error by the Upper Tribunal. Our position is as set out at paragraph 40 of our skeleton. To run through the point, or the points, it's as follows. The UT itself notes, Upper Tribunal 133 to 134, that the FTT accepted Mr. Elborne's evidence that the, quotes, sole purpose, close quotes, FTT para 18.1, for the implementation of the scheme was the removal of the value of the property from Mrs. Elborne's estate. That evidence
wasn't a trustee.
Correct. He wasn't a trustee. The Elborne parties didn't advance any evidence or pleading or argument of any other purpose of the scheme. And there was and is no dispute that the note is a document that was entered into solely for the purposes of the scheme. And so I say that on the FTT's findings, the only purpose that explains the terms of the scheme documents is the purpose of the scheme itself, i.e. purportedly to enable Mrs Elborne to remove the value of the property by way of the note from her inheritance tax estate whilst continuing to live at the property rent-free for as long as she wished. Now, my learned friend cites the case of BlackRock, Authorities Bundle, tab 48, 1027, Elborne Skeleton, paragraph 25.4, for the proposition that to ascertain the purpose of something is to inquire into the subjective intention of the relevant actors. Bear with me. Yes, at 25.4 of the Elborne Skeleton, ascertaining the purpose of something, quotes, involves an inquiry into the subjective intentions of the relevant actor, close quotes, BlackRock, paragraph 124. The problem with that is that it misses part of the quote. So could we go to BlackRock, please?
To remind me again, where is it?
Tab 48,
Thank you.
page 1027. So the case starts at 1027, and the passage quoted is at paragraph 124. So that's Authorities Bundle 1056. In particular, it's paragraph 124A. So what's going on here is that 124 refers to Lord Justice Millett's useful summary. That's a summary from a case called Vodafone, brings out the point already referred to and derived from Malalieu and McKinley. For present purposes, object can also be regarded as synonymous with purpose. So far as relevant to this case, and gathering the points together, I would summarise the key points as follows. And so it's A. A, save in obvious cases. Save in obvious cases. And then the passage that's quoted in Malone and Skeleton, ascertaining the object or purpose of something involves an inquiry into the subjective intentions of the relevant actor. Now, I say that save in obvious cases beginning is important. If we go back to paragraph 122, one can see that we have a quote from Lord Justice Millett beginning, and at 121 we see the first word Vodafone. So it's referring to a case called Vodafone in which Lord Justice Millett gave the judgment, and it concerned the purpose of a payment. And if one goes down to the foot of the page, 1055, final sentence on page 1055, which is within the quote of Lord Justice Millett and Vodafone, some consequences are so inevitably and inextricably involved in the payment that unless merely incidental, they must be taken to be a purpose for which the payment was made. So yes, it will often be a question of looking at the subjective aims of a particular individual, but sometimes a consequence is inextricably linked. It's inevitable. It's inherent in what goes on. And in those circumstances, Lord Justice Millett said it must be taken to be a purpose. Now, I say that in this case, the consequence of the life trustees issuing the note on the terms they did, within the framework of the scheme, and of course on the premise that it was effective, which axiomatically was the premise on which Mrs Elborne and Mr Wolfe, trustees of the Life Trust, were acting, then inevitably the note had no role to play other than as an element of the scheme.
It provided consideration for the sale of the property.
As part of the scheme.
Yes, but it provided consideration. I mean, you can't avoid that. Maybe part of the scheme. I note actually, looking at the passage at para 124 in Blackrock, since we're looking at the whole of it, that little d says that motives are not necessarily the same as objects or purposes, and little f says it's for the fact-finding tribunal to determine the object or purpose sought to be achieved, and that question is not answered simply by asking the decision makers. So your position would be stronger, I would have thought, if the fact-finding tribunal, here the first-tier tribunal, had said in terms the object was tax avoidance. The sole object is tax avoidance. Because it's a necessary inference and it's so obvious that it couldn't be anything else. But I don't remember seeing a passage that says that.
Well, the FDT said at 2441 that the scheme was, quote, designed to enable Mrs Elborne to continue living in the property while at the same time reducing the value of her estate by an amount equal to the value of the property. Mm-hmm. So I would say that is the finding. Okay. Millett's point is that often the right thing to do will be to ask the decision maker, as it were, but one has to have a healthy dose of realism in some context. And I would say this is precisely such a context. Precisely such a context. No one disputes that the note was an element of the scheme. Mr. Elborne, Mrs. Elborne's son, yes, not a trustee, stated what he said the sole purpose was, and I am asserting that it's unavoidable that the consequence of the life trustee issuing on the notes and the terms that they did within the framework of the scheme as a whole inevitably is that the note had no role other than as an element of the scheme. No one suggested any other role.
We don't have any evidence, do we, of the circumstances or terms in which this scheme was sold to the Elborne family?
We don't have a letter. We do have the witness evidence in the witness statement that was put forward and is in the bundle.
Yes.
To say that it arose following Mrs. Elborne investigating ways in which...
I suppose what I'm really asking is, do we have any evidence of what... I'm not suggesting we necessarily should have, it's just I want to make sure I haven't missed anything. Explaining how and on what terms the scheme was sold, whether the steps were set out in a kind of... in a chronological fashion, with or without a commentary as to what they were designed to do and what their purpose was, or was it bought off the peg or anything?
We just... My Lord, you haven't missed anything. There isn't that sort of...
Okay.
There isn't that sort of correspondence in there. But I'm simply making the brute submission that if ever there was a case where there is, as it were, is an inevitable consequence inherent in the set of arrangements, that this note has one purpose and one purpose only. Mm. And indeed, the son of Mrs. Elborne has described it as the sole purpose. Yes, he's not the trustee. I say this is such a case, and those first words in 124A of Blackrock, and the end of the quoted passage at the foot of 122 in Blackrock are absolutely on point here. So I do say the upshot is that neither of the 2 points that the Upper Tribunal takes against me at 135, rejecting this contention, is a good point. I would therefore submit that if the court is not with me on grounds 1 to 3, the court should be with me on ground 7.
And just to be clear, the answer to the point I was putting to you at a very early stage about the need to pinpoint exactly what it is you're relying on as the point of construction, which brings Rossendale analysis into play, you refer us to your skeleton argument 39.1 and 39.2.
Precisely.
Yeah, thank you.
I'm grateful for that moment. I'm about to move on to section 102. Just before I do, I think one final point on section 103. My lady, Lady Justice Andrew, was saying, am I saying, therefore, that the deeming makes the beneficiary the trustee? I'm not saying that, and I don't say that I need to say that. And I don't say that the deeming needs to go that far. Certainly that's not how the FTT viewed matters. And I'd also make the point, of course, that the trustee doesn't have an estate, as it were. We're looking at the estate immediately before death of the deceased. The trustee doesn't have an estate. That's common ground. So if it's viewed as a trustee's liability, one doesn't get to ask whether there's a deduction or not. And we have to ask that question. We're looking at the position immediately before the date of death. So I don't say that the deeming makes them the trustee. I do say it's relevant to ask in circumstances where the legislation says they're to be treated as the owner of the assets, and at least in one sense, whether via net property or other, they can get, as it were, the benefit of the fact that this liability could come off. There has to also be a mechanism whereby you can ask whether the liability should come off at all. That's the point I keep trying to make. I suspect not very articulately, but that's the point.
Okay, we've got it.
Right. Section 102. And this is grounds 4 to 6. So we're looking at section 102, and this is in the context of the note. So section 102 can be looked at by the loan note, or it can be looked at by the property. We're going to start by looking at it via the loan note. Perhaps we could go to the statutory provision. So authorities bundle, tab 8, page 50. So what I'm going to do is take things in two stages. First of all, I'm going to run through the legislation in fairly headline terms, and then I'm going to turn to particular points in more detail. And in terms of the first of those two steps, Section 102 comprises a number of components, and taking matters first at a relatively high level, one can perhaps see the section as comprising 5 elements. That's how the Upper Tribunal analysed the position. stating that there were 5 components that needed to be in place for Section 102 to bite, and that there was agreement in relation to several of them. So, Upper Tribunal, paragraphs 139 to 140, the court can go there if they wish, but I'll read out what is said at 139. There are 5 components that must be satisfied for the note to fall within Section 102. Number 1, there's an individual. Number 2, that individual disposes of property. Number 3, that disposal is by way of gift. Number 4, the position is such that the case comes within 102.1a or 102.1b. And number 5, the requirements of 102.3 are met, i.e. property would not otherwise form part of the donor's estate immediately prior to death. And those 5 elements which the Upper Tribunal has picked out all latch on to particular bits of wording within the section. And then, sorry, I've sent you to the legislation, but I'm now referring to the decision. And then at 140, the Upper Tribunal says this: it was common ground that the requirements of 1, 2, 3, and 5 were satisfied in relation to the note. Common ground 1, 2, 3, and 5 satisfied in relation to the note. So that leaves element 4, i.e. whether the requirements of 102.1a or 102.1b were met. One further preliminary point to note: it should be noted that Section 102 is to be read as being supplemented by Section 20 of the 86 Act. One gets that from 102.8, which is over the page. Schedule 20 to this Act has effect for supplementing this section. And that, in due course, brings us to the notion of associated operations, which is para 6.1c of Schedule 20. We'll come back to that. So, with that, as it were, as the backdrop, I'm going to pick up the story in paragraph 26 of my skeleton, where, yes, there was no dispute before the Upper Tribunal that 4 of the 5 conditions were met. However, the Upper Tribunal nevertheless held that the position was such that the case did not come within 102.1b or 102.1a, and therefore determined the Section 102 note issue against the revenue. HMRC to challenge 3 aspects of the Upper Tribunal's analysis. These are grounds 4, 5, and 6. So ground 4 concerns the second limb of 102.1b, ground 5 is the first limb of 102.1b, ground 6 is 102.1a. I'm going to take the grounds in that order. It's the first of those where the vast majority of the work and the heavy lifting will be done, ground 4. So, we're looking at the second limb of 102.1b. The inquiry is whether the following words would apply to the case. So, if one still has the legislation to hand, 102.1b, that at any time in the relevant period the property is not enjoyed to the entire exclusion or virtually to the entire exclusion of any benefit to him, either donor, by contract or otherwise. So taking the analysis in stages, first of all, 2 preliminary points. Number 1, in terms of the relevant period, we know this is the 7-year period ending with the death of the individual in question. That's the tailpiece wording to 102.1, ending with the death of Mrs Elborne in January 2011. Number 2, in terms of the property in question, this is the loan note that the court will recall was gifted by Mrs Elborne to the trustees of the family trust as part of the scheme. And that was in late 2003 or early 2004. So the question under this second limb of 1021B is whether the gift of the loan note is enjoyed to the entire exclusion by virtue, or virtually to the entire exclusion of any benefit to Mrs Elborne by contract or otherwise. Both the Upper Tribunal and the FTT held that it was, i.e. the second limb of section 1021B did not bite. I say they were wrong to do so, and I'm going to work through why I say that. I want to start by looking at what the tribunals found in particular, because they did find that some of what the legislation required was in place. So in particular, both tribunals did find, in the context of examining the loan note, that Mrs Elborne as donor did receive a benefit by contract or otherwise. The FTT found this requirement that there be a, quotes, benefit to him by contract or otherwise was, quotes, clearly satisfied. FTT 258. In fact, it'd be great if we could go to 258. The FTT's decision. Picking it up so for context, we're here within the loan note issue, which begins at FTT 238. There's a reference at the beginning of 258 to the above conditions. That's a reference back to 257. We'll look at that in a moment. And indeed, 257 begins with looking at the answer to the first of those questions. That takes one back to 256. We'll look at that as well. But within 258, picking it up a few words in, the tribunal says this: the first condition, so that's i.e. the first condition set out in 2571, i.e. enjoying a benefit during the relevant period. The first condition is clearly satisfied by virtue of the benefit to Mrs Elborne of being able to occupy the property following the gift of the note. That was a benefit to Mrs Elborne by contract or otherwise for the purposes of 1021B, because regardless of whether it arose by virtue of the terms of the note itself, as Mr Davies submitted, it certainly arose by virtue of one or more of the transactions which were, quotes, associated operations in relation to the gift of the note, such as the agreement to transfer the property to a settlement under which Mrs Elborne enjoyed an interest in possession, or the terms of the life settlement trustees resolution. So that's what the FTT says there. I say it's an important finding, and it's correct. A few points to unpack. As regards the reference to associated operations, 3 lines up within 258, the court will recall that a moment ago I referred to section 1028, which points one towards schedule 20 as supplementing this section. I'd be grateful if we could go to schedule 20, please. That's authorities bundle 8, tab 8, page 56. So schedule 20 is headed gifts with reservation. And then within schedule 20, we go to paragraph 6, which is headed exclusion of benefit. So that's 2 pages further on, foot of the page on page 58, exclusion of benefit. Paragraph 6.1 begins, in determining whether any property which is disposed of by way of gift is enjoyed to the entire exclusion or virtually to the entire exclusion of the donor and of any benefit to him by contract or otherwise. And then we go down to little c, so just above the hole punch on page 59. A benefit which the donor obtained by virtue of any associated operations as defined in section 268 of the Act, 84 Act, of which the disposal by way of gift is one, shall be treated as a benefit to him by contract or otherwise. So the nub of the point is that if you're looking to see whether property disposed of by way of gift is enjoined to the exclusion of any benefit to the donor by contract or otherwise, then the class of potentially relevant benefits includes, by virtue of paragraph 6.1c, a benefit obtained by virtue of any associated operation. Now, in terms of the definition
And
of a...
I'm so sorry to be slow, but that would be, you would say, her life interest under the life interest trust. Being able to continue to live there.
Yes. And the FT...
Whereas she was entitled to live there before because she was the owner.
She was, which is a different interest,
Yes.
which we'll come on to. But yes, the FTT cited a couple of what it called associated operations. I'll go to both of them specifically, but yes. In terms of the definition of associated operation, we get that at Section 268 of the 84 Act, that's page 45 in the bundle. And I won't read it out, but I'd be grateful if the court would read Section 2681 on page 45 of the authorities bundle. I'm grateful. So what the FTT is saying at 258, which we looked at a moment ago, is that the fact that Mrs Elborne occupied the property was a benefit to her by contract or otherwise for the purposes of 1021B, and I'm quoting from paragraph 258, because regardless of whether it arose by virtue of the terms of the note itself, it certainly arose by virtue of one or more of the transactions which were associated operations in relation to the gift, such as, and then it lists two things. One, the agreement to transfer the property to a settlement under which Mrs Elborne enjoyed an interest in possession. Or two, the terms of the life settlement trustees resolution. So those are two associated operations that the FTT spots. Now, as regards the first of those, the agreement for sale was an agreement to transfer the freehold to the life settlement. One gets that in the definition of property on page 1 of the agreement for sale, supplemental bundle, page 37. And clause 1.4 of the life settlement, which makes Mrs Elborne the life tenant of the life settlement. And then as regards the second associated operation, the terms of the life settlement trustees resolution, well, the resolution was a resolution that Mrs Elborne would be eligible to live at the old rectory during her lifetime. So that's, I'm not sure we need to turn it up, but we can if it would be helpful. It's recital F of the trustees resolution, supplemental bundle, page 44. And part 2 of the schedule to the trustees resolution, supplemental bundle, page 45. So that's what the FTT found and held. The Upper Tribunal agreed with the FTT on this. Upper Tribunal, paragraph 187, first sentence. And the Upper Tribunal said this, quotes, on the facts here, Upper Tribunal 187, first sentence. On the facts here, we agree not only with the FTT's description of the benefit, being Mrs Elborne's ability to occupy the property, but also that this benefit arose by virtue of one or more of the transactions which were associated operations for this purpose. So, why, notwithstanding those findings, was the point not determined in the revenue's favour? Well, you'll recall that at First Tier Tribunal 258, it referred to Mrs Elborne's receipt of a benefit by contract or otherwise as the first condition. That was referring back to 257, which sets out what the FTT says were 3 conditions which must be satisfied if the case is to fall within the second limb of 1021B. So perhaps if one has the FTT decision to hand, at paragraph 256, the FTT posed 2 questions, and we're looking at the first one. The enjoyment of the note by the trustee of the family settlement was to be the exclusion or virtually the exclusion of any benefit to Mrs Elborne by contract or otherwise, second limb of 1021B. Then at 257, the FTT says you've got to satisfy 3 conditions. We've looked at the first, and that is satisfied. But the reason the FTT didn't determine the point in the revenue's favour is because although it held that Mrs Elborne obtained an advantage or benefit from the situation, it was one which the FTT considered did not bear the right sort of relationship to the other features of the situation. In particular, the FTT considered that the advantage or benefit, number 1, arose too early, FTT 259, tallying with FTT 2572, and or, second issue, it did not impact on or trench upon the donee's enjoyment of the gifted property, FTT 260, tallying with FTT 2573. And I want to explore both of those points now. So, first question to deal with, did the benefit arise too early? Well, on this point, the FTT and the Upper Tribunal differed, at least in part. The FTT said this at 259, having made the finding that it did at 258, which we've looked at. However, that benefit was something which Mrs Elborne enjoyed before she made the gift of the note to the trustees of the family settlement, and indeed before the scheme commenced, and the chain of associated operations in relation to the gift started. That benefit was not something which arose for the first time as a result of either the gift or any associated operations in relation to the gift, and consequently we consider that the condition set out in 2572 above is not met. Now, the Upper Tribunal held, I say rightly, that that analysis included an error. This is Upper Tribunal 191. At Upper Tribunal 191, second sentence, the Tribunal said this, the Upper Tribunal said this, however, at FTT 259, the FTT had also relied on this benefit having been enjoyed before the scheme commenced. The FTT's reasoning did not have regard to the different capacities in which Mrs Elborne occupied the property, and to that extent we conclude that this reasoning involved an error of law. So what the Upper Tribunal is saying is that the FTT had identified correctly, in the Upper Tribunal's view, the benefit which Mrs Elborne enjoyed as being the right to occupy the property, but then fall into error in saying that this was a benefit that she enjoyed prior to the scheme. Because that fails to take account of the fact that once Mrs Elborne and others had pressed play on the scheme, as it were, her right to occupy the property as freehold owner fell away. It derived not from her previous capacity as freehold owner, but from her new, within the scheme, different capacity, namely that of life tenant under the life trust. That capacity and right did not exist prior to the scheme. It was therefore a benefit which she enjoyed by virtue of the scheme and not prior to the scheme. That was the Upper Tribunal's position. And I say that's correct. However, the Upper Tribunal considered that it was important that there was a period of a matter of few weeks after implementation of the scheme began and before implementation of the scheme was complete, during which Mrs Elborne enjoyed the benefit that she obtained under the scheme, i.e. as beneficiary under the life trust, but had not yet assigned the loan note to the trustees of the second trust. So the Upper Tribunal said this at 190. Picking it up about halfway through. Mrs Elborne had occupied the property as holder of the interest in possession, i.e. in the same capacity as she occupied after the gift, between the 27th of November 2003 and late January or early February 2004, when the note was assigned to the family trustees. Whilst this ability to occupy did arise in this period by virtue of associated operations, Para 61C did not operate to treat the timing of the events as being different to that which actually occurred. And in this situation, we conclude that the benefit to Mrs Elborne did not consist of an advantage which she did not enjoy before she made the gift of the note. Now, here we say the Upper Tribunal went awry. Various points to make here. First, insofar as the Upper Tribunal is saying that Para 61C of Schedule 20 of the 86 Act, which we've been to, does not explicitly state anything about the timing of events, that is true. But I say that's not the point. The real question, questions to focus on, I say are twofold. The first factual and the second legal or analytical. The first is this. What are the actual circumstances of that period of a few weeks between the first trust being set up and the assignment of the note to the second trust being made? And the second is, having got those circumstances clear, the second is whether or not, in the context of the implementation of this scheme, the court is obliged to analyse the steps in the implementation slavishly one by one in strict chronological order in order to arrive at the right analysis, or whether a more holistic analysis is acceptable, indeed necessary. Dealing with the first of those first. So the Upper Tribunal's focus is on a period between late November 03 and late January or early February 04. Upper Tribunal paragraph 190. But it's worth noting that simply stating those dates doesn't quite tell the whole story. Certainly the intention of the parties appears to have been that the elements of the scheme would be implemented in an extremely short space of time, i.e. over just a matter of a few days, rather than longer. A quick way to see that is from the index to the supplemental bundle. All of the scheme documents, i.e. items 2 to 11, date from either late November or early December 03, 27th of November 23 to 8th of December 23. In addition, I'd like to go to the FTT's decision. Could we go to paragraph 21 of the FTT's decision, please? And I'd be grateful, so it's on page 230 of the bundle, it's paragraph 21 of the FTT's decision. I'd be grateful if the court would read paragraphs 21, sub 1 to 3, and then the first sentence after that, none of those statements was true. So paragraphs 21, 1 to 3, and then ending with none of those statements was true. I'm grateful. So in short, insofar as Mrs Elborne's benefit under the scheme predated the assignment of the loan note by anything more than just a handful of days, it was by virtue of the somewhat haphazard fashion in which the scheme itself was implemented, nothing more. One might also note yes, FTT, beginning of the following paragraph, FTT paragraph 22, first sentence. Those differences between the manner in which the scheme in fact unfolded and the manner in which the scheme was intended to operate have done nothing to assist the appellant's case. Now, though the fact FTT was not focusing on the specific point we're looking at now, I do say the sentiment is apposite. It would be, I suggest, surprising, or at any rate ironic, darkly ironic, if in a scheme context, the problematic implementation of the arrangements were to work in the scheme user's advantage in sidestepping what I say is an anti-avoidance provision. In any event, whether one analyses the time period between the creation of the benefit to Mrs Elborne under the first trust and transfer of note to the second trust in terms of a few days or a few weeks, does the existence of that short period of time make, as the Upper Tribunal seem to think, all the difference as a matter of legal analysis? I say no. This is precisely where the Ramsey approach of analysing fact patterns in an unblinkered, real-world fashion is absolutely critical. I could take the court to any of a dozen or more judicial dicta to make this point. I'll go to two, if I may. First of all, Rossendale at 12, tab 42, page 762. Tab 42, 762. Another aspect of the Ramsey approach is that where a scheme aimed at avoiding tax involves a series of steps planned in advance, it is both permissible and necessary not just to consider the particular steps individually, but to consider the scheme as a whole. Permissible and necessary. And picking up the same theme, the passage we looked at before the short adjournment, beginning of paragraph 17, the facts must also be looked at in the round. Lord Steen explained that it was the formalistic insistence on examining steps in a composite scheme separately that allowed tax avoidance schemes to flourish. And one could also look at Ramsey itself, tab 23, at 258 to 9. Picking up principle 4 in Lord Wilberforce's judgment. Given that a document or transaction is genuine, the court cannot go behind it to some supposed underlying substance. This is the well-known principle, Duke of Westminster. This is the cardinal principle that it must not be overstated or overextended while obliging the court to accept documents or transactions found to be genuine. As such, it does not compel the court to look at a document or a transaction in blinkers, isolated from any context to which it properly belongs. If it can be seen that a document or transaction was intended to have effect as part of the nexus or series of transactions, or as an ingredient of a wider transaction intended as a whole, there is nothing in the doctrine to prevent it being so regarded. To do so is not to prefer form to substance or substance to form. It's the task of the court to ascertain the legal nature of any transaction to which it sought to attach a tax or a tax consequence, and if that emerges from a series or combination of transactions intended to operate as such, it is that series or combination which may be regarded. The Commissioners considering a particular case, it's wrong and an unnecessary limitation to regard themselves as precluded by their own finding that documents or transactions are not shams. from considering what, as evidenced by the documents themselves, or by the manifested intention of the parties, the relevant transaction is. They are not under the Westminster doctrine or any other authority bound to consider individually each separate step in a composite transaction intended to be carried through as a whole. In short, this court will need to decide whether what is, I would suggest, in effect, a scintilla temporis between the creation of the benefit and the effecting of the gift, both linchpins of the scheme, is such as to entail that the benefit does not come within 102(1)(b). The Upper Tribunal considered that it didn't come within it. In my submission, this court should reach the contrary view. In the case of Ingram, Lord Hoffman commented that he did not, quote, think that a theory based upon the notion of a scintilla temporis can have a very powerful grasp on reality. Page 303F of the House of Lords judgment, Authorities Bundle 40426. I would suggest that that may be sage advice when it comes to analysing the present case.
Except on no view can a period of several weeks be classified as a scintilla temporis.
Well, you have my submissions on the point.
Yes.
The court will recall that a little earlier I was running through what had been the FTT's analysis on section 102(1)(b), second limb. I'd said that the FTT had held that Mrs Elborne did obtain an advantage or benefit from the situation, but it was one which did not bear the right sort of relationship to the other features of the situation for two reasons. The first was that the advantage arose at the wrong moment. I've just made submissions on that. The second was that the advantage did not impact on, or in the language of some of the case law, trench upon the donee's enjoyment of the gifted property. That was FTT 260 tallying with 257 sub 3. And I'm now going to make submissions on that. So, trenching. From the court's reading in, it may have become apparent that the issue, which is usually known as trenching, or perhaps more precisely cluster of issues, has been around for a while. In my submission, breaking it down, there are really three questions to consider. Number one, what is trenching? What is this idea or concept meant to connote or consist in? Number two, is the presence of trenching in a fact pattern A necessary condition of 102(1)(b) second limb applying, or alternatively B, simply one indicia, one potential means of demonstrating in relation to certain fact patterns that the requirements of the legislation are or may be met. And then number three, in any event, if and insofar as it's a relevant consideration in this case, is it satisfied? I'll give you my answers to those questions in a nutshell straight away. Number one, the concept of trenching is not the crystal clear, quasi-scientific concept that sometimes appears to be contended for. Number two, as regards the second and third questions, I'd be grateful if the court would read paragraph 33.3 of the revenue skeleton, or if it's more helpful, I'll simply read it out. The Upper Tribunal also erred at imposing a trenching requirement, alternatively holding that any such requirement was not met. Although some case law refers to trenching, not all does, and it's admitted that there's no statutory trenching requirement in the sense of it constituting a necessary legislative condition the application of 102(1)(b). Each case will turn on its own facts. As noted by the Court of Appeal in Hood, a given case may be such that it obviates the need for any separate inquiry as to whether the benefit was referable to or trenched upon the gift. Alternatively, in any event, any trenching requirement was met. On a realistic view of the multifaceted scheme in the present case, the relationship between the benefit and the gift was such as to answer to the statutory description. So, those are my answers to the three questions in a nutshell, and I'm now going to work through the analysis as to how one gets there. I'm going to take the first two questions together, since considering what trenching is, conceptually, I say in part provides the answer to whether or not it's a necessary condition. Taking the analysis in stages, I say the position is as follows. The starting point is that there is no definition of trenching under the Inheritance Tax 1984 or the Finance Act 1986. Indeed, there's no reference to trenching at all in the legislation. It is not part of the statutory language. It is rather a word, a concept, that appears in some judicial decisions in this area. Not all, some. Now, there are a fair number of cases in the bundle concerning Section 102, or predecessor legislation. I'm going to refer to some of them. I will be as efficient as I can.
Are you going to take us to one that supports the proposition that trenching isn't necessary?
I am, my lady. I'd like to start by going to the case of Attorney General and Worrell, which is the Authorities Bundle, tab 12, page 89. So Worrell is the earliest, or at any rate one of the earliest cases in the canon. It concerns Section 38 of the Customs and Inland Revenue Act 1881 and Section 11 of the Customs and Inland Revenue Act 1889, both provisions of which are in the Authorities Bundle at pages tab 1 and tab 2, pages 5 and 7, which together constituted, I think, the first incarnation of what is now Section 102 of the Finance Act 86.
Sorry, I just got lost. Which tab are we in?
Tab 12 of the Authorities Bundle, the case of Attorney General and Worrell. It was a case which involved the following factual elements, simplifying slightly, but I hope accurate enough. Number one, James Worrell lent money to Robert and Mary Shield. Number two, that loan was secured by way of mortgage on the Shields' property. Number three, following failure to pay, Mr. Worrell began proceedings to foreclose on the mortgage. In the course of those proceedings, an order was made giving the mortgagor 6 months to pay what was due. Number four, in the meantime, the son of James Worrell, Edward Worrell, bought the mortgagor's interest in the property, i.e. the equity of redemption, from the Shields. Number five, James Worrell released the mortgage debt which had been secured against the property. Number six, Edward Worrell covenanted to pay his father an annuity. Those were the elements in that case. Were the facts caught by the legislation? Answer, yes. Could we go to the decision of Lord Justice Lopes, please? Page 96 of the bundle. If one picks it up at the third question, so by the second hole punch. The third question was whether this property was personalty passing to the son in such a manner as to come within the provisions of the statutes relating to account duty and estate duty. And the property there is the value of releasing the mortgage debt. This depends on the provisions of two statutes, Customs and Inland Revenue Act 1881 and the Customs and Inland Revenue Act 1889. There was a defect in the provision of Section 38 sub 2c of the earlier Act that in order to bring a case within it, there must be a reservation out of the subject matter of the gift. It appears to me that Section 11 sub 1 of the subsequent Act of 1889 was worded as it is with the express purpose of avoiding that defect. It provides that description of property marked A in the former enactment shall, quotes, include property taken under any gift whenever made, of which property bona fide possession and enjoyment shall not have been assumed by the donee immediately upon the gift and thenceforward retained in the entire exclusion of the donor or of any benefit to him by contract or otherwise. As I read that provision, it's not necessary that the benefit to the donor should be by way of reservation, but any benefit to him by contract or otherwise will suffice to bring the case within the enactment. Applying that construction of the word to the present case, it seems to me impossible here to say that there was no benefit to the donor by contract or otherwise within the meaning of the Act. I think that there was clearly, in this case, such benefit by contract as was contemplated by the section. If we go over one page, we can also pick up the end of Lord Justice A.L. Smith's judgment, paragraph beginning thirdly on page 98 of the bundle. Thirdly, it was argued that as there was no benefit retained by the donor out of the subject matter of the gift, the case did not come within the subsection, but I do not so read the enactment. It appears to me that it was framed expressly for the purpose of making the net wider than it had been under the former Act. Therefore, I think that all the points taken with the defendant fail and the appeal should be dismissed. And also, one final sentence back on page 95. This is at the end of the decision of the Master of the Rolls. Penultimate sentence by the second hole punch. It appears to me that the covenant by the son to pay an annuity to the father prevented this from being a pure and simple gift, and therefore it comes within the statute. So, that's Worrell. There's certainly no mention of trenching, and indeed I'd suggest the tenor of the judgments is against putting a gloss on what the legislation says, and recognising that the legislation is now of greater breadth than prior to the 1889 amendment. Next case, could we please go to the case of the Attorney General and Earl Grey? That should be tab 13 in the bundle. They're just a couple of pages further on, page 99. Again, it's a case where there's, as far as I can see, no reference to trenching. Earl Grey's was a case which concerned the third Earl Grey's estate in Northumberland. The third Earl was the son of the Prime Minister and famous tea drinker, the second Earl. And the third Earl entered into a transaction with his nephew, the fourth Earl. The elements of the transaction included that the third Earl would transfer to the fourth Earl all his real estate, and the third Earl would get various things, including a rent charge out of the property, an obligation on the part of the fourth Earl to pay the third Earl's funeral and testamentary expenses, and an obligation on the part of the fourth Earl to pay all the third Earl's debts. And
also was permitted to occupy the manor house for life, wasn't he?
he was. An efficient way of seeing some of that information is the very first sentence of the head note on page 99. It was argued on behalf of the late Earl's estate that the gift was only of the balance. It's 2 lines up from the bottom on page 100. That was given short shrift. Looking at the matter realistically.
Very short.
Very short.
And very obvious. Because it's quite clear that the donor retained an interest.
So if we pick it up at the second hole punch within the Earl of Halsbury's decision, in this case, can anybody doubt that something has been reserved to the settlor? The settlement itself is reserved at £4,000 a year, and has reserved a right also on the part of the settlor that all his debts up to the period of his death should be paid, and the payment secured by the estate. It seems to me that it's burning daylight to say that it's not within the express language of the statute.
It's one of the later cases, I forget which describes the judgment of Lord Halsbury here as unreserved in more senses than one.
It does, my lord. Rather nice turn of phrase. But I say the relevance here is the analysis might be, you can see the benefit as arising out of the gift, i.e. the rent charge issuing out of the fee simple. or you can see it as distinct from the gift, i.e. the obligation to pay the debts. But either way, it was caught by the legislation.
Well, they've gone down the former route, not the latter.
Well, in my submission, they went down both routes. I mean, I'm probably disinclined to go there in the interest of time, but if the court wants a longer version, the Court of Appeal decision is in the supplemental bundle and goes through it in intricate detail. Perhaps I'd just ask the court to read that decision. The submission I simply make is that you can see the advantage to the donor as being something that is reserved out of the gift that was given, or you can see it as something distinct from it. On either footing, the legislation catches. The next case I'd like to go to is a case called St Alban. It's at tab 20. Page 163 in the bundle. It's a 1952 case, so we're half a century later.
I hope you're not asking us to understand all the ins and outs of it. It's an exceptionally complicated case.
It is. Well, Lord, I've thought very carefully about how to do this, and I hope the way I'm going to do it is the right way. It's certainly true that Lord Simmons described the facts, perhaps with a degree of understatement, as somewhat involved. So, this may not be the very first occasion on which the concept of trenching is used expressly, but it's certainly a fairly early outing, and it's a case which is often cited on trenching. It begins, as I say, with Lord Simmons. Which one's it? 165. Yeah, second sentence. Second paragraph. The facts of the case are somewhat involved, but present no real difficulty. I'm going to set out what I say the facts of the case are in 7 steps, just so hopefully there's some context. And I am then going to go to a passage which is longer than a passage one would normally go to, but I hope the court will indulge me. So the 7 steps are as follows. Number 1, Lord St Levan had a beneficial interest in various assets held in trust. Number 2, a company was set up and the assets of the trust sold to the company in return for consideration comprising a lump sum of 950,000 and a right to receive 750,000 by 40 equal instalments. Number 3, on the same day, the company issued the trustees of the trust with 50,000 shares, and the trust paid the company £850,000 for the shares. Number 4, so the net effect was that the settled property had been converted into 50,000 fully paid ordinary shares, a right to receive 750,000 by 40 equal instalments, and £100,000, i.e. what was left of the original 950. Number 5, the 100,000 and the right to receive 750,000 by 40 equal instalments were then settled on new trusts, the Lord St Levan, absolutely. Number 6, Lord St Levan then paid the company the £100,000 and got 100,000 preference shares back. And then finally, number 7, the 50,000 ordinary shares were settled on a new trust in which Lord St Leven had no interest. Lord St Leven then died, and the question arose whether estate duty was due in connection with the 50,000 shares. And the court held no. Now, taking stock, the essential point being put by the Crown was that it was because Lord St Leven retained an interest in some assets, that should be seen as bringing within the section the disposal of the 50,000 ordinary shares. The court rejected that, and it's in Lord Radcliffe's decision that the concept of trenching is, if not born, then referred to. And with apologies in advance, I'm going to go through, as a longer passage than one normally would, but I think it's the best way of doing it. Could we go to page 194? And if we pick it up by the second hole punch, beginning with "but unless it is a valid proposition." So here, Lord Radcliffe is pushing back on the suggestion that if you view the arrangements globally, there are benefits which Lord St Leven has, which means the disposal of the 50,000 shares at the end is caught by the legislation. He says this: "But unless it is a valid proposition of law, that for the purposes of section 43, so we're now up to section 43 of the Finance Act 1940, that's the incarnation at this point, bona fide possession and enjoyment of property is not assumed and retained to the entire exclusion of any benefit to a person by contract or otherwise, merely because it is found that after releasing a limited interest in the property, that person continues to enjoy contractual benefit created as part of the whole scheme in which that release is involved. Do not see that the recital of the facts that I've set out above brings the Crown any nearer to establishing its case under section 43. I'm afraid there's a good deal that is yet to be said on this appeal, but in substance the case for the Crown stands or falls by that proposition. If it's right, the wording of the section is indeed inapt to express its meaning. But to adopt it requires no more than to ascertain whether the deceased was left in possession of any contractual benefit at all at the end of the transaction, and gives no significance to the question whether that benefit, whatever it is such as to trench upon the possession and enjoyment of the property in which the interest has been surrendered. My own view is that the whole proposition is fallacious, nor do I think it's better founded if the qualification is introduced that a benefit by contract to be within the mischief of the section must be referable to the transaction by which the life interest is determined. Your Lordships were invited to accept that qualification because the words in question had been used by Lord Tomlin when delivering the opinion of the Judicial Committee in Munro, but there is a difference between using words to explain a point and using words to define a proposition, and the words referable to are in themselves of too ambiguous an import to afford any satisfactory gloss upon the meaning of the section. There is much, and not more than much, to be said for the proposition advanced by the Crown. It was decided long ago in Worrell that a contractual benefit may interfere with the exclusive possession and enjoyment required by such a provision, in that case section 11.1 of the 1889 Act, even though it does not amount to a reservation out of the property that is the subject of the gift. My lords, so it may. For my part, I see nothing in the decision of Worrell's case that cannot readily be accepted as good law. But what did it decide? A father had made a present to his son of a sum of about 24,000 secured on mortgage, and the son had bought in the equity of redemption for a small sum. In return for his father's gift, the son had covenanted to pay him an annuity of 735 per annum. In effect, the son was returning to the father the income on the property given during the remainder of the father's life. It seems to me reasonable enough for a court to hold that in those circumstances, the son had not obtained the enjoyment of what was given free from a contractual benefit to the father, which encumbered the enjoyment of the very thing that was given. To hold otherwise would have been to stop at the mere form of the transaction. Even if I do not think that Worrell's case was rightly decided as I do, I should not think it right at this stage to suggest that it ought to be overruled. It stood too long and has been too often relied on, but I think it is a very mistaken form of reasoning to deduce from a decision that a benefit to be within the mischief of the section need not necessarily be by reservation out of the subject matter of a gift. The general proposition that all benefits are within the mischief of the section whether they are by way of reservation out of the subject matter of the gift or not. To deny the validity of one general proposition is not to assert the general validity of its opposite. I suggest, therefore, that your lordships can safely put aside the case of Worrell as having no further bearing on this appeal than that of showing that the benefit of the instalment payment which Lord St Leonard retained was not without the mischief of the section merely because the company's contract to pay them was neither a charge upon nor a reservation out of the property which consisted of the ordinary shares. That's the 50,000. But it leaves unresolved the essential question whether that benefit was nevertheless within the mischief of the section. So, that's what it says. And his lordship is saying a range of things there. Including, he says at one point that one might view the legislation as being inapt to express its meaning on one analysis. He's sceptical about the utility of talking in terms of a benefit being referable to the gift or transaction. That's something else he says. He also says he thinks that Worrell was rightly decided. He also says he accepts that a contractual benefit may interfere with the enjoyment of a gift, even if it is not a reservation out of the property which is the subject of the gift. But he seems to say that it does not follow from that that all benefits will come within the Act. He also makes the philosophical point that to deny the validity of one general proposition is not to assert the general validity of the opposite. He also seems to be saying that each case will turn on its own particulars, that final sentence, but it leaves unresolved the essential question whether that benefit was nevertheless within the mischief of the section. I would suggest that on a fair reading, one thing he's not saying is that the presence of trenching will necessarily, in all cases, be an essential ingredient in the analysis. It's also worth noting that while Lord Radcliffe mentions trenching, Lord Simmons doesn't. And that's relevant not least because not so long after St Alban, about 5 years later, in another case in this area, Lord Simmons, by that stage Viscount Simmons, is again part of the panel and says something directly relevant for our purposes. So could we go to a case called Chick, please? This is in the supplemental authorities bundle at tab 2. So this is a 57-58 case, and it concerns the Stamp Duties Act. It's an Australian case. It's the...
Well, that's a Privy Council case.
Privy Council case, quite right, yeah. Privy Council case. On appeal from the Supreme Court of New South Wales, Privy Council, and it's dealing with the Stamp Duties Act, 1920 to 1956. And one sees the wording of that in the first paragraph of the headnote. The case was a case about a gift of farming property in Australia. So the facts, again, are different. We don't need to go to them. The reason I do go to this case, though, is for what Viscount Simmons says in relation to trenching. It's at 449 of the decision. That's page 29 of the bundle. So Viscount Simmons had been part of the bench in St Alban. He's now sitting in Chick. Now, to be clear, in Chick what was being analysed in particular was a different part of the section. So it's limb 1 as opposed to limb 2 of what is now section 1021B. But nevertheless, I say that what is said in relation to the second limb is relevant. If you pick it up at 449, taking it from 2 lines above the second hole punch, Where the question is whether the donor has been entirely excluded from the subject matter of the gift, that is the single fact to be determined. If he's not been so excluded, the eye need look no further to see whether his non-exclusion has been advantageous or otherwise to the donee. It must be observed that in Oakes's case, the board appears to be dealing with the second level of the subsection, the question being whether the donor was entirely excluded from any benefit to him, of whatever kind or in any way whatsoever. It is possible that in the consideration of this very difficult part of the subsection, it may be pertinent in some cases to inquire whether the benefit derived by the donor is one that impairs or detracts from the donee's enjoyment of the gift. So it's possible that it may be pertinent in some cases to inquire whether the benefit derived by the donor is one that impairs or detracts from the donee's enjoyment of the gift. Their lordships, with great respect, think that is a matter which may require further examination.
And so this is obiter.
It is obiter. But I say the language is careful and the source is important. So we're now up to the late 1950s. And certainly as at this stage, the Privy Council, yes, obiter does not consider that trenching is a necessary condition. Now, the cases we've looked at so far, Worrell, Elgrey, St Alban, and Chick, concern a range of assets. We've got real property, annuities, shares, transfers of money, and so on. There have, of course, been more recent cases dealing with Section 102. We refer to some of them in our skeleton, and a number of them are in the bundle. To name a few, there is Nichols, 1975, judgment of Mr Justice Goff. There's Ingram, 1997 in the Court of Appeal, and 2000 in the House of Lords. There's Bozzoni, 2014 in the Court of Appeal. There's Hood, 2018 in the Court of Appeal. Those aren't the only ones, but those are a few of the key ones. One observation I would make is that in all of those, the gift is of real property. In Nichols, it was the Nichols family seat in Essex, Lawford Hall in Manningtree. In Ingram, it's Hurst Lodge in Berkshire. In Bozzoni, it was a property in Knightsbridge. In Hood, it was a property in Chelsea Square.
And the significance of that is?
The significance of that is a key reason for the courts having to pedal hard in relation to Section 102 has been what Lord Hoffman in Ingram described as, quotes, the highly sophisticated English land law. Page 300b of the House of Lords judgment. Backdrop against which a number of these cases arises, meaning that differing proprietary interests can, as Lord Hoffman puts it, quotes, coexist with other interests in the same physical object. Page 304G of the House of Lords decision, and cited in our skeleton at paragraph 35. But that is not this case in relation to this ground of appeal.
I can't see why that makes a difference in principle. You can have different interests in other types of real property, other types of property. You can hold an object on trust for somebody, hold money on trust for somebody.
That's absolutely true, my lady. What I'm saying is that if we're looking at 102.1b in respect of the loan note, which under grounds of appeal 4 to 6 we are,
Yes.
the question is not that of whether or not real property rights might coexist in the same physical object. Rather, it's a case about the meaning and the application of the words which Parliament has chosen to use. Property not enjoys the entire exclusion of the donor. when confronted with a financial instrument, either note, which is drawn up and acting as the linchpin in a scheme, the terms of which have been sculpted specifically for Mrs Elborne's advantage, with the practical consequence that Mrs Elborne retains the use of the property indefinitely. Put another way, I say that in this case, the facts are not obviously amenable to a trenching analysis. That doesn't mean that it's out with the legislative scheme. Rather, it means that each fact pattern demands and deserves to be analysed in its own right, and its relationship with the legislation ascertained in its own right. Sometimes a fact pattern might look familiar, perhaps normal in inverted commas, but not always. And if the circumstances are unusual, then peering over the hedge to look at furrows previously ploughed in an adjacent field might not necessarily tell one what to do this time round.
Well, it peers over the hedge largely to find out what the principles are that should be applied by reference to which one answers the question. Doesn't one?
One absolutely does, milady. What I'm trying to do is undermine
isn't part of the principle.
Undermine the proposition that trenching is a necessary condition in each and every case.
Yeah.
Rather, I say it's an indicia, it's an analytical tool which may be of use in some cases. Two final cases that I want to refer to in this passage. One is Bozzoni. I think perhaps we could turn that up. That's tab 37 in the authorities bundle.
That was the case where the taxpayer succeeded, if I remember rightly.
Yeah.
My lord does remember rightly. Yeah.
Because I had to take some pains to distinguish it in Hood.
Indeed. Tab 37, page 651. Very briefly, the facts. The deceased, Leah Carmi, had a head lease, a 100-year lease of a flat in Knightsbridge. She granted an underlease to a nominee for a trust company, which was the trustee of a trust for the benefit of her two sons. The question was whether the underlease was caught by 1021B as being enjoyed, quotes, to the entire exclusion or virtually entire exclusion of the donor or any benefit to her by contract or otherwise. The underlease contained covenants that the underlessee would observe covenants in the head lease. And separately, the underlessee entered into like covenants with the head landlord direct. It was held that the facts were not caught by 1021B. Various questions arose. One question which arose concerned the source of the benefit which the donor obtained from the arrangements. One can see a heading above paragraph 17, page 657 of the bundle. The source of the impugned benefit. And to cut a long story short, the court held that it came from the underlease, which was the subject matter of the gift. One sees that from the last line of paragraph 29, over on page 661. And then, if we pick it up at paragraph 30, this is Lord Justice Moses, who says this under the heading, Impact on the Exclusivity of the Donie's Enjoyment. The Revenue says that conclusion is dispositive. Once it is concluded that the benefit was derived from the gift, that, they say, is the end of the inquiry. Not so, says the taxpayer. This second limb of the subsection focuses on enjoyment by the donee of the gifted property, not enjoyment by the donor of the benefit. The question, so the taxpayers submit, turns on whether the donee's enjoyment is to any, save a minimal extent, impaired or reduced. If the impugned benefit makes no difference to the enjoyment of the property in question, then it cannot, so the argument runs, be said that it has ceased to be exclusive. Mr. Torb, the taxpayer, contends that the impugned benefit made no difference to the donee's enjoyment of the underlease because the underlessees, under the licence to underlet, had already entered into covenants with the head lessor, which mirrored those contained in the underlease. In light of the covenants entered into directly by the underlessees with the head landlord, the covenants with the underlessor, the deceased, did not detract anything further from their enjoyment of the underlease. It was already stamped with the obligations to the head landlord, which the covenants with the deceased merely duplicated. So that was the framing of the issue. It then led Lord Justice Moses to consider the law. If we go over to paragraph 34, that included the source of the trenching contention, and there's a reference there to St Alban. And at paragraph 36, we see the quotation from St Alban that we looked at earlier. And then in the following paragraphs, there are references to various cases, including Worrell via St Alban and Chick, which is referred to at 45, and others too. And then if we note the conclusion at paragraph 49, the authorities do not, as it seems to me, carry the taxpayers so far as they wish to go. They do show that it may not be sufficient to ask whether the donor has received a benefit. Not all benefits, said Lord Radcliffe, come within the section, St Alban. The inquiry must go further and ask whether the benefit is derived from the property comprising the gift or from property which was not so comprised. But none of the authorities turn on any further inquiry as to whether, even if it was derived from the gifted property, benefit was at the cost or expense or to the detriment of the donee's enjoyment. Lord Radcliffe's explanation of Worrell's case suggests that if a benefit is not derived from the subject matter of the gift, it falls foul of the section if it has an impact on enjoyment of the gift. But it's not concerned with the consequences where, as I've concluded, the benefit is derived from the subject matter of the gift. So that's Lord Justice Moses' reading of the case law. Then at 50, it seems to me that there's sufficient support for the taxpayer's contention to be found in the wording of the subsection. The second limb of section 1021B of the 86 Act requires consideration of whether the donee's enjoyment of the property gifted is to the exclusion of any benefit to the donor. The focus is not primarily on the question whether the donor has obtained a benefit from the gifted property, but whether the donee's enjoyment of that property remains exclusive. The statutory question is whether the donee enjoyed the property to the entire exclusion or virtually to the entire exclusion of any benefit to the donor. The benefit to the donor does not have any impact on the donor's enjoyment, in my view, then the donor's enjoyment is the entire exclusion of any benefit to the donor. Lord Justice Millett said, to come within the scope of the second limb of the subsection, the benefit must consist of some advantage which the donor did not enjoy before he made the gift. That was sufficient in Nichols and would have been in Ingram, where any such advantage clearly would have had an impact on the subject matter of the gift. But whilst that's a necessary condition, there will be cases in which it's not a sufficient condition. As I have said, the subsection, in its focus on the exclusivity of the donor's enjoyment of the gifted property, may demand further inquiry as to whether the benefit has any impact on the donor's enjoyment. If the benefit is irrelevant to such enjoyment, it does not trench upon the exclusivity of the donor's enjoyment. May demand further inquiry.
Well, that's if it's not a sufficient condition. If it's a necessary condition, there will be cases in which it's not a sufficient condition. And then he's going on to explain that if it's not a sufficient condition, you might have to have further inquiry.
Yes.
I think that's a fair reading, isn't it?
And then finally, Hood. That's at tab 40, page 710 of the bundle. So the facts were in a number of respects remarkably similar to the case of Bozzoni. But one thing that was different was an absence of direct covenants between underlessee and head landlord. And the court described that as the significant difference between the two fact patterns. That's at page 2372F, page 728 of the bundle, and just above the second hole punch. It's worth noting that Hood includes what I would describe as a magisterial journey through the case law, starting at paragraph 20. I don't think any submission I've made has been inconsistent with anything said in that journey.
No, I don't think it has.
And then if we come to paragraph 60 and 61, I'd be grateful if the court would read paragraph 60 and 61. I'm grateful for that, if the court's had sufficient time. And I would, well, obviously the court will see that there will be cases, as stated at the end of 61, that obviate the need for any separate inquiry as to whether the benefit was referable to or trenched upon the gift. That's how the Court of Appeal puts it there in the penultimate sentence of paragraph 61. The court also goes on to make further insightful observations in relation to the case law, in particular at 65 to 66. I'm not going to go through those now, but I would ask that they be taken into account. Where does that leave us? In my submission, where it leaves us is that trenching is not a necessary condition. As expressed in Chick at 449, it may be pertinent in some cases to inquire whether the benefit derived by the donor is one that impairs or detracts from the donee's enjoyment. It may be pertinent to undertake a separate inquiry, to use the phrase in Hood, in some cases. So, we've been looking at questions 1 and 2. Since I say that trenching is not a necessary condition, to the extent that the FTT and the UT held to the contrary, FTT 2573 and Upper Tribunal 194, I do say they erred. However, if the court disagrees that trenching is not a necessary condition, or is of the view that even if it's not a necessary condition, it is a relevant avenue of analysis in the present case, and here we're under question 3 of the 3 questions I posed a little earlier, then 2 issues arise. Number 1, what would trenching really consist in? What would it look like in a case like this? And number 2, on the facts, is it met? It's worth noting what the Upper Tribunal said in rejecting my contention that trenching is not a necessary condition in order for the second limb of section 102(1)(b) to bite. Could we go to 194 of the Upper Tribunal decision, please? And if one picks it up at by the first hole punch, so about 2/3 of the way through the paragraph, well, we really can't avoid the first sentence. We do not accept Mr. Davies' submissions. Picking it up 2/3 of the way through, in stating, and it's referring to my Lord Launcelot Henderson's decision in Hood, in stating that this obviates the need for any separate inquiry as to whether the benefit was referable to or trenched upon the gift, Lord Justice Henderson was referring to the fact that, as he framed it, one could not have existed without the other. Lord Justice Henderson was not saying that there is no requirement that the benefit trench upon the enjoyment of the gift, rather that the requirement is clearly satisfied where the benefit is integral to the gift. Now, for my own part, I'm not quite sure that is what my Lord was saying in that passage. But in any event, what the Upper Tribunal is saying is that if it can be shown that a benefit enjoyed by a donor is integral, to use the Upper Tribunal's word, to the gift received by the donor, or by the donee, then it can be said that the trenching requirement is met. Now, as I say, it's not obvious to me that that's necessarily the same understanding of what trenching involves as is found in parts of the case law, including Lord Radcliffe in St Alban. Which, of course, in turn, I would say, itself goes to the point I made earlier that trenching is not some quasi-scientific term or process. But leaving that aside, what would it look like for the benefit to be integral, to use the Upper Tribunal's word, integral to the gift in the present case? Well, whatever it might look like, the Upper Tribunal didn't think it was exhibited in the present facts. So at 195 they said this: here the benefit to Mrs Elborne did not trench upon the family trustee's enjoyment of the note. As we've identified above, whilst the note was not repayable until after Mrs Elborne's death, where Mrs Elborne lived until then had no bearing on this. But is that right? I say it's not right. It's not right whether as a matter of contractual analysis or as a matter of practical reality.
Well, if she chose to go and live in the south of France, for her health in her declining years, the trustees of the loan note would still be obliged to pay the money back.
Well, perhaps I can develop the point in this way. First, by focusing on the fact that there were circumstances in which the note would be repayable prior to Mrs Elborne's death. And then secondly, considering the position in any event, by leaving aside the fact that there were circumstances in which the note would be repayable prior to Mrs Elborne's death. I say on either footing, if there is a trenching requirement or a legitimate trenching inquiry to be undertaken, then it is passed successfully. So first, focusing on the fact that there were circumstances in which the note would be repayable prior to Mrs Elborne's death. So in terms of the contractual analysis, I say it's not correct to say that the note was not repayable until after Mrs Elborne's death. That's what the Upper Tribunal had said at 195, and it's not correct. In certain circumstances, the note would be repayable prior to Mrs Elborne's death. That's clause 4 of the loan note, headed Events of Default. It's at page 42 of the supplemental bundle. We can turn it up if it's of assistance, but we don't have to if the court does not require that.
Sorry, you said
Page
supplemental
40,
bundle at...
supplemental bundle, page 42.
Thank you, I'm sorry. I have tabs in mine, I was thinking there are 42 tabs. Anyway.
Apologies,
thank
I
you.
should have included the tab reference.
No, it's fine. So this is the promissory note that you're taking us to repayment.
So, yes, hopefully there's a page there above the first hole punch. Clause 4, Events of Default. And my submission is that given that there were circumstances in which the loan note would become repayable prior to Mrs Elborne's death, where Mrs Elborne lived absolutely did have a bearing on the note holder's enjoyment of the loan note, because it brings to the fore the question of how the loan note would have been paid off. This is where the practical reality of the situation has to be factored in. The only asset which the life settlement had was the freehold of the old rectory. Selling the old rectory was the mechanism whereby the life trustees would be in a position to pay off the loan note if they needed to. But the old rectory couldn't be sold off precisely because, at the time that the scheme was entered into and effected, Mrs Elborne and Mr Elborne were living there. And Mrs Elborne and Mr Elborne remaining in the old rectory was an integral part of the scheme. Various points here. The life trustees, of which Mrs Elborne was one, had resolved that Mrs Elborne would have the right to reside rent-free at the old rectory, quotes, during her lifetime and for so long as she so desires, close quotes. Life Trustees Resolution, Part 2, that's supplemental bundle, page 45. In Mrs Elborne's letter of wishes to the Life Trustees, i.e. herself and Mr Wolfe, she'd stated explicitly that it was her, quotes, wish that the old rectory should not be sold until appropriate arrangements had been made for the care and comfort of my husband, Robert Edward Monckton Elborne, Mrs Elborne was writing that at a time when she and her husband were living in the old rectory, with Mrs Elborne caring for Mr Elborne. The oral evidence of Mark Elborne, Mr and Mrs Elborne's son, was that his father had suffered a brain hemorrhage in the early mid-1990s, in fact a second brain hemorrhage following an earlier one, and Mrs Elborne was caring for him at the old rectory. That's transcript day 3, page 7, lines 15 to 16, which is in the bundle. And further, in giving oral evidence, Mark Elborne also said this. This is transcript day 3, lines 3 to 10. My mother and father were living in the property. She'd expressed a wish over many years that she live in it for her life. She was very protective of my father, who was quite unwell, became more frail. It was a family property that had been built by one of my father's mothers, one of the Monktons, and it was a sort of personal wish that we tried to keep the property in the family. Now, to say in those circumstances, the fact that Mrs Elborne and her frail husband were living in the only asset that could have been used to repay the loan had no bearing, did not trench upon the enjoyment of the loan note by those to whom it was assigned, I say is wholly unrealistic. Had the loan note become repayable under clause 4 of the loan note, it could not have been repaid without selling the house. And that was not going to happen because the assignees of the loan note were Mrs Elborne's children, and as one of them said, Mrs Elborne, quotes, had expressed a wish over many years that she live in the old rectory for life.
So clause 4.6 has no meaning. Practical terms, clause 4.6, you might as well put a red pen through it. I mean, that envisages the very thing that you just said would not happen because of her beneficial interest. And yet it's there in black and white saying, if we default, we'll sell the property. And her interest, of course, is not protected because it's unregistered land and they didn't put a caution on it.
What I'm saying is that the trust had one asset, and on an unblinkered, realistic analysis of the facts, the trust was not going to turf out Mrs Elborne and Mr Elborne in the circumstances which I've just described.
See, the problem I have with all of this is that you expect us to take at face value the provisions of 4.1 and so on, and say that's realistic, when in fact the reality is that most of those provisions are not going to be operative. And then you say, well, we can ignore 4.6 because on an unblinkered basis, she's going to be living there.
What I'm putting before the court is the fact that the Upper Tribunal erred when it said there were no circumstances in which the loan note would become repayable prior to death. That's not correct. And then I'm coupling with that the analysis that on the facts of this case, there was only one asset. It was the freehold, and all of the evidence indicates that it was not going to be sold, either because of the terms of the life trust, or because of the letter of wishes, or because of the factual circumstances of the people who were living there, coupled with the evidence of one of the trustees of the second trust, who would have been a party who, in theory, would have been pushing for the enforcement of the loan note. I'm simply putting before the court the contractual provisions coupled with the factual circumstances. I said I had two submissions to make. First of all, focusing on circumstances, as it were, prior to death.
I'm sorry, I'm just also looking on at the trustees' resolution, which is at the next divider in the supplementary bundle, page 44, operative provisions. And operative provision 3, we hereby declare that the life tenant shall have a right to occupy until further notice. So they could give her notice.
They could give her notice, yes. My submission is that in practice that was never going to happen. I mean, either the court likes the submission or they don't.
Yeah.
But my point is twofold. Number one, there were circumstances in which the loan note came to be repayable, in theory, prior to death. And number two, in practice, the trustees had one asset, and it's the very asset in which the person who set up the scheme was living with her frail husband and had asked to remain. It was not realistic that they were going to utilise that asset to pay off the loan note. That is most sensibly analysed on a realistic analysis of the facts as therefore trenching upon the enjoyment of the donees of the loan.
Even though they would be contractually obliged to do so, and they have the power to do it by giving further notice, giving notice, as my lady has pointed out, to the person occupying the property.
I think the court has the submission.
Yes.
And then secondly, focusing on the position in any event, by leaving aside the fact that there were circumstances in which the note would be repayable, or theoretically fall to be repayable prior to Mrs Elborne's death. So both the First Tribunal and the Upper Tribunal took the position that the fact that a benefit is, quotes, integral to the gift, close quotes, to use the Upper Tribunal's wording at paragraph 194, does not preclude it from being a relevant benefit for the purposes of section 102. That's FTT para 260 and Upper Tribunal para 194. But they then went on to find that ultimately that didn't make a difference on the facts and the question of whether section 102.1 be applied, because on the tribunal's analysis, the benefit which Mrs Elborne received was not, quotes, integral to the gift itself. The FTT expressed the point in this way at paragraph 260. Whilst the benefit which arises as a result of a term in the gifted property is not precluded from being a relevant benefit for the purposes of section 102, that is true only of a term which is created as part of the gift itself. In other words, the FTT was saying that that would not be the position if the benefit and gift are distinct. My submission is that on an unblinkered, realistic view of the facts, the benefit and the gift were not distinct, but inextricably connected. And for a foothold in my skeleton here, it's paragraph 33.1. I asked in opening that as one moves through the undergrowth, the court does not forget to look up and see the view. And I say this is precisely when that request and suggestion becomes relevant. This was a multifaceted scheme which Mrs Elborne instructed her solicitor, Mr Wolfe, to set up, and I would say was imbued in its very bones with advantage to Mrs Elborne. The benefit to Mrs Elborne was, as it were, baked into the terms of the gift, in that absent an event of default, we've already looked at that, the loan note could not be crystallised until after Mrs Elborne's death. How, I say, can it possibly be said that Mrs Elborne did not derive a benefit from that? I do say it's impossible to look at the loan note in a vacuum, cut off from the surrounding contextual elements, including the identity of the person to whom the gift was given, i.e. her 3 children, the benefit to Mrs Elborne, i.e. her occupation of the property, was, as it were, manifested in the terms of the loan note by virtue of the fact that, absent an event of default, the loan note could not, as I say, be crystallised until after death. In short, I say, number one, trenching is not a necessary condition and is not a requirement in this case. But if the court's not with me on that, then number two, the trenching requirement is met.
Is that a convenient moment?
If it's a convenient moment for the court, then it's a convenient moment for me.
But what does that mean?
Well, I suppose what it means is,
You'd like to go on?
well, what it means is I would say I have fewer than 10 minutes of submissions left to make. So if the court wished
In relation to
in relation to
102.
finalising this ground 4, and then just very quickly speaking to grounds 5 and 6. I said earlier that ground 4 was where the heavy lifting
Yes.
is doing.
Well, I think you should do it then, as long as everyone is concerned.
And if that is where we get to, then that would mean that the court won't have to hear from me tomorrow morning and can immediately hear from Ms Belgrano.
10 minutes and counting.
Okay. So, just to draw the threads together on 102.1b second limb, which is what we've been looking at, ground 4. In short, I say the section is satisfied. We do have an individual, Mrs Elborne. We do have a disposal of property. It's the loan note. It is a disposal by way of gift. No suggestion that there was any consideration given for the loan note. And section 102.1b limb 2 was satisfied for the reasons I've just submitted. The final question to ask is the one raised by section 102.3, which is to ask whether the property would not, apart from this section, form part of the deceased's estate immediately before death. And the answer is it would not form part of the estate immediately before death, precisely because it was held in the family settlement, in relation to which Mrs Elborne was not a beneficiary. So the 102.3 requirement is met. And therefore, ground 4 should succeed. That leaves grounds 5 and 6, which I can take, I hope, very shortly. I've been focusing on the second limb of section 102.1b, but what I've been saying is also relevant regarding the first limb of 102.1b. To remind the court, 102.1b is focused on the situation where, quotes, an individual disposes of any property by a gift, and b, at any time in the relevant period, the property is not enjoyed to the entire exclusion or virtually to the entire exclusion of the donor and of any benefit to him by contract or otherwise. So if we're looking at the first limb, the key words are property is not enjoyed to the entire exclusion or virtually to the entire exclusion of the donor. So the question is, what do those words mean? What is their import and application in a case such as the present? My submission is very simple. To enjoy an asset which comprises rights under a financial instrument necessarily involves being able to exercise those rights. Therefore, the question is, can it be said that the assignees of the loan note, i.e. the trustees of the second trust, did enjoy the loan note, quotes, to the entire exclusion or virtually to the entire exclusion of the donor, when, as I've submitted, the practical reality is that their contractual rights as loan note holders were in part stymied, i.e. in practice, repayment under clause 4 was not going to happen, for the reasons that I've already set out a few moments ago, by virtue of the benefit which Mrs Elborne enjoyed under the scheme, i.e. her occupation of the old rectory in the circumstances which I've described. And my answer is very simply no, it can't be said that the assignees enjoyed the loan note to the entire exclusion of the donor for the reasons I've given. Beyond that, I essentially rely on what we say in paragraphs 34 to 35 of our skeleton. That's to say the Upper Tribunal erred in holding that the first limb of 102.1b could not apply to the note. As I say, the note was not enjoyed to the entire exclusion or virtually to the entire exclusion of Mrs Elborne, since the terms of the note, agreed as an integral part of the scheme, coupled with Mrs Elborne's appointment as life tenant under the first trust, ensured that the liability which the note represented could not be redeemed prior to her death, and that she would continue to have the right to reside at the property until her death. The Upper Tribunal, in holding what they held at paragraph 200, referred to the case of Ingram, which I've referred to briefly. But I do say that the answer to the present case does not lie in the specific facts of another, and judicial statements in respect of legislation in this area tend necessarily to be tailored to the facts of the case in question. So, when Lord Hoffman said that, quotes, and this is page 304G of Ingram, section 102 does not prevent people from deriving benefit from the object in which they've given away an interest. It applies only when they derive the benefit from that interest. He's saying that against, as I've said before, this land law backdrop. This case is not about, certainly if we're looking at the loan note, it's not a case about differing proprietary rights in the same physical object. It's about the meaning and application of Parliament's words to the particular facts in question. When we look at the note, which is a linchpin in the arrangements that were set up, which, as I said before, was sculpted specifically for Mrs Elborne's advantage in the way that I've described. And therefore, on a realistic, context-sensitive analysis, I do say that Mrs Elborne plainly derived benefit, quote unquote, to use Lord Hoffman's formulation, from the note. That's all I wanted to say on ground 5. I think that leaves me 4 minutes on ground 6.
Which is 102.1a.
Yes. Again, I can deal with this quickly because the work has already been done. In terms of references, this is First Tier Tribunal paragraphs 2562 and 261. It's Upper Tribunal paragraphs 202 to 208. And essentially, I'm happy to rest pretty much on what we say in paragraph 36 of the skeleton, because essentially the submissions I've made apply again. I say that the Upper Tribunal erred in holding that possession and enjoyment of the note was bona fide assumed by the family trustees. That was the finding at Upper Tribunal 205. As with the Upper Tribunal's analysis in respect of 1021B, I say that the Upper Tribunal failed to apply the legislation purposively to the facts viewed realistically. The Upper Tribunal held that the fact that the note was not due to be repaid until after Mrs Elborne's death was merely, quotes, a consequence of the terms of the note. Upper Tribunal 205. But in my submission, for the reasons I've already given, that finding reflects a failure by the Upper Tribunal to appreciate the nature and significance of the note's functional role set within its proper context, i.e., as a financial instrument which advantaged Mrs Elborne, giving rise to what I would describe as a manufactured liability, which might never be repaid. And the court may have seen that there's legal advice to that effect, which is referred to by the FTT, paragraph 15 sub 8, core bundle 227. Yes, where legal advice was sought on, quotes, whether the note had to be repaid or whether it can now be forgiven in circumstances where the beneficiaries of the two trusts are identical, question mark. And the note as constituting, as I've said before, a key element within a multi-transaction structure. I say that at all events, the present case is caught by section 1021A and the reasons that I've already submitted. I just have one moment. I'm grateful for the additional time. That takes us to the end of ground 6. So I've dealt with 1 to 7. Unless the court has any further questions on those, then in the morning, Ms Wilgrano will address the court on grounds 8 to 10.
Thank you very much indeed.
Thank you.
Court rises able.